President and the Judges of the Caribbean Court of Justice.
All rise. Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, Dominica. CCJ Appeal number 3 of 2018 between Gloria Shillingford versus Angel Andrew for the hearing of the appeal this morning. Can we have the appearances for the court, please? Thank you.
May it please you, my Lord President, Honorable Justices of Appeal and Milady, I am Lennox Lawrence with Jody Luke. For the appellant is present.
Yes, the respondent.
For the respondent, I am Michael Rooney. I am with Ms. Lisa Discretus. The respondent is not present since he is normally resident in England and he wasn't able to make the trip. I do apologize for that.
Yes, thank you and good morning, Counsel. Mr. Lawrence, are you ready to begin?
Yes, please, my Lord President, we are ready to begin.
Mr. Lawrence, before you actually commence, how much time did you plan to take?
Well, we had intended to take an hour. We were allowed an hour.
I see. Okay.
And we, but to assist and to keep us within the hour, Lord President, we had submitted this morning speaking notes.
Yes.
We do not propose to go very well, my Lord. Yes, because we thought that it would assist us in staying within the time allotted.
Yes. Yes, please proceed.
Yes, please. Before your lordships and your leadership is an appeal from the decision of the Court of Appeal of the Commonwealth of Dominica. The entire judge is contained at pages 150 to 185 of the record, and we'll refer to the judgment as we go along. This centers on three distinct areas: the constitutional law on adequate time and facilities for the preparation of offense, as in Section 8 of the Constitution. Number 2, on the proper application of the mandatory provisions of the CPR. And number 3, on the ambit of a trial judge's discretion, if any, in the face of clear non-compliance. The second area would be the law on delegated authority. And this area will be critical for this judgment because it's centered heavily on the issue of the legal maxim delegatus non potest delegare. But our submissions were filed on the 29th of November, and at paragraph 1 to 5 of the submissions, we set out a summary of facts that we wish to rely on. At paragraph 6 to 20, we set out a chronology. which we present for your Lordships and your Ladyship's considerations. At paragraph 24 to 67, we set out the evidence and the findings at trial, which are highlighted for the purposes of this appeal, and which we submit, my Lord, for your consideration as being significant. The summary of the evidence of agency and sub-agency contained at paragraphs 25 to 38 of the file submissions. And at paragraph 39 to 55, we set out our analysis of the sale and purchase price insofar as is relevant to this appeal. And importantly, paragraphs 56 to 83, we address the general issues of law as relates to the law of agency. With respect to the law of agency, there are two matters that we will rely on. The two powers of attorney, one which was drafted by an attorney, and we will submit that this one was very precisely drafted, and that's between the parties before your Lordships and your Ladyship. On the other hand, there is a loosely drafted power of attorney, which was said to be an exclusive power between the appellant and a third party, which is not before your Lordships and your Ladyship. With your Lordship's leave and your Ladyship's leave, we would wish to argue ground of appeal number 4 first, my Lord. And ground of appeal number 4 is that the learned justices of appeal in the court below erred in law and misdirected themselves in failing to find and or to declare that the trial conducted by the learned trial judge between the 18th April 2011 and 20th April 2011 and the judgment flowing therefrom were in nullity for the flagrant disregard and or violation of the CPR. My Lord, inherent in this ground are critical matters of constitutional and procedural law, which inherently govern civil litigation in Dominica. And in this regard, we refer to Section 8(1)(b) of the Constitution of Dominica, which requires that a citizen be provided with adequate time and facilities for the preparation of a defense, particularly in this case where issues of fraud were raised, and there are criminal sanctions, certainly, that would arise from the issue of fraud.
Mr. Lawrence,
Lord, we refer
Mr.
to...
Lawrence,
Yes, please.
was this argument raised before Mr. Justice Cottle?
My Lord, that was not... Well, first I will say, from a review of the record, the fraud was hinted at, but I did not see in my review of the record, I did not appear below at the trial, but I did not see arguments specific to fraud.
No, I'm not talking about fraud. I'm talking about the fact that the trial that you were about to embark upon, that your client was about to embark upon, was a nullity.
But at appeal, those submissions were raised with the leave of the court. I did submit to the Court of Appeal on those.
But they weren't raised at first instance, were they?
No, my Lord, I had not. I did not see that in the record, in my review of the record. As I indicated, I was not the attorney involved at the trial. But I had leave of the Court of Appeal, my Lord, to submit on that.
Basically, the problem is that your client voluntarily, willingly, aided by counsel at the time, embarked upon a trial. Now, suppose he had succeeded, suppose the client had succeeded, would they have been claiming that it was a nullity?
Well, my Lord, I would hope not. I don't think that they would.
Well, you see, this is the point. It's rather late in the day now to make these kinds of claims.
You can't have your cake and eat it. On the other hand, tails I win, heads you lose. In that the point was discussed before the trial judge, and the trial judge went ahead on the basis, I think, that trial counsel had already seen most of the documents in the record. There were only a few that had not been seen, and the trial judge made it clear he'd be sympathetic when matters relating to those came up. And on that basis, counsel seemed to be prepared to go ahead. So you can't, on the one hand, say, well, I'll go ahead, and if I lose, I'll claim it's all void, but if I go ahead and win, I won't. And it's intriguing also,
well,
of course, this point was only raised in the Court of Appeal on the very day the appeal was being opened before the Court of Appeal. So the matter can't have struck you as being particularly significant, of having caused severe damage.
Well, the matter was raised, that submission was filed before the hearing of the appeal. We had leave to file that, and we had filed the submission before, and we did argue it on appeal.
Counsel, could we get back to the trial? The proceedings opened with counsel who filed the bundles late, drawing that failure, that lapse on his part to the attention of the court and apologizing. Is that correct?
That is correct, my lord.
And then there was the going through of what took place. That certain bundles were filed at an earlier stage, but that the preparation of the last 3, I think, was delayed. Is that correct?
No, my lord, my understanding is that all the bundles were filed on the night before. My understanding is not that bundles were filed previously. My understanding that the bundles for the trial were filed the night before, or served the night before the trial.
Page 707 and 708.
Yes, please.
Mr. Bruno opens. My lord, I take the opportunity to apologize sincerely. There has been a certain amount of non-compliance as the preparation of the trial bundles turned out to be much more complicated than were originally anticipated. In fact, the large volumes of the documents that constituted the trial bundles were only received on the night before, although we have tried to have them hustled and filed before, at least by Friday. We could only be successful by filing 2. As it was over the weekend, we succeeded in filing the trial bundles with the documents for this trial. So that seems to indicate that 2 were filed before. Yeah?
But 2 were, the way I understood it is that 2 were filed by the Friday. And on the weekend, over the weekend, the others were filed.
Okay.
We had tried to have them at line 10, although we had tried to have them hustled and filed before, at least by Friday, or maybe the Friday before the Monday. We could only be successful by filing 2, and I would take the reference here to be 2 by the Friday, as it was only over the weekend we succeeded in filing the trial bundles with the documents for this trial.
Well, look at page 709, Counsel. Line 4.
Yes, please.
My lord, the documents that are on file are mainly documents that were submitted to us by the first defendant. There is one document that is in the file that may not have been on the list of documents, but it is. I don't think that it is anything that will prejudice the case of the first. It affects only the first claimant in the first instance and will only prejudice the case if there is, in fact, an admission of events that it is related to. So what strikes me, Counsel, is that there was a clear examination of the content of the violation or departure from compliance. Is that your impression as well?
No, my lord.
Sorry?
Could you repeat? Could your lordship repeat, please?
That there was a clear examination before the court of the contour, the scope of the non-compliance, and what were the implications of the late filing. Is that your understanding?
No, my lord, I think my understanding that it goes a bit further, because from line 8 and following, in the first instance, and will only produce the case if the is in fact an admission of events that it relates to. If there's any objections, the documents could be included from the bundle. It is a document that came late, very late, and we have documents from England. We had documents from the United States.
Yeah.
So it's appeared from my understanding and the reading of this, Millard, and it goes further. It is easy to explain because it's an email affecting both the first defendant and referring to a matter that the first defendant had already admitted. All the other documents that are in the trial bundles are documents on the list.
Counsel, do you understand what you're saying? You are identifying that there is one, or possibly more than one, but certainly one you are talking about, document in this bundle of 5 volumes.
Well, my Lord, in looking at the bundle, the reference to emails and other documents raised the inference that it could have been more than one document.
But Counsel, the short point is that if it is more than one document, and I think you're made out, you're verified at page 710, line 12, where Mr. Bruni identifies the documents that are referred to. Page 710, line 12.
He did, my Lord, yes, he did.
The documents that the email messages are referred to are on the 3rd side of the bundle, part 1, pages 25, 27, and 28. So 3 pages.
Right. Yes, my Lord.
So this is really what came in late, what could have inconvenienced Counsel for Gloria?
You know, on that basis, Mr. Richards, it seems, decides to go ahead. If you look at the top of page 711, when he says, "Yes, my Lord, save for my plea that your Lordship understands any difficulty we might have relating to those documents which counsel referred to." And the court says, "Okay, yes, Mr. Bruni shall be proceed," and Mr. Bruni agrees. So both counsel proceed to agree to have the case dealt with, since they're all there and ready.
3 documents, Counsel.
Well, the 3 documents, but the scope of the non-compliance went beyond the 3 documents which were filed late, were filed in that bundle on the morning of the appeal. Because the bundle, my Lord, should have been filed. My Lord, because the bundle, the rules require that the bundles, those documents should have been disclosed 21 days before, and the bundle filed 10 days previously under the rules.
Yes.
You mean apart from these 3 documents, you were never apprised of the other documents in the bundle until they were filed? Or is it that you are complaining that although you were aware of the documents, there was simply a non-compliance with the time in which they were filed? Because there's a big difference between those 2 things.
Yes, sir. My Lord, from the reading of the transcript, is the complaint would be that there would have been, though I do not have the list of disclosed documents, but reading the transcript, it appears that there was disclosure. But there were documents, those documents now identified, were not previously disclosed.
The documents at pages 25, 27, and 28 are documents which may not have been previously disclosed. Is that correct?
That is my understanding of the transcript.
But all of the other documents that comprised the trial bundle were documents which were previously known to your side.
Most of them were produced by your side.
Well, my Lord, from the transcript, as I indicated, I was not in the court below, but from the transcript it appears so.
Well, it's the transcript we have to go by, Mr. Lawrence.
Yes. Yes, my Lord. So I'm saying it appears so. It appears that the documents from the transcript.
Mr. Lawrence, I can help you, you know. I can help you by showing that it is not simply what appeared so. As a matter of record, there is a listing of all the documents, and if you look at the record beginning at page 105,
yes, please.
You will see the record of appeal. And then, if you look at page 109, you will see the documents used at the trial in the High Court.
Yes, yes, my lord.
Attachments to defense of the second and third ancillary defendants, attachments to amended statement of claim, and look at them, power of attorney from Angel to Gloria, agreement between Gloria and Caribbean Investment, extension of time agreement from Gloria, additional extension from Gloria, agreement between Angel and Gloria, attachments to documents with the statement of Lennox Lawrence, RBC transfer, memorandum of transfer. If you look at them, Counsel, all of them, or sorry, in the mean, they are from Gloria.
But that is correct, my lord.
So then what is your point about your constitutional rights having been so violated that the trial was rendered a nullity?
In the light of that, Mr.
Well,
Lawrence, just if you could put this in the mix, what is the terrible unfairness of this trial that causes your constitutional rights to have been breached?
Well, the way our submission is that those documents, namely the emails, we're not speaking of the documents submitted by the appellant herself. The emails should have been disclosed at least 21 days before the trial, or at the very minimum 10 days before the trial, so that as provided by the rules, so that the appellant could have instructed counsel in relation to them.
Yes, Counsel, we understand that. This is the second time you're telling us. But the question is, what injustice was caused?
See, Mr. Richards was prepared to go ahead and didn't raise any points about the trial bundle being so late that the witness statement shouldn't be allowed to stand and so on, and that the case should be a nullity. And the judge was prepared to go ahead, and so implicitly was waiving any possible sanctions. So in the interest of justice, since everyone was there and the bundles were there and most of the stuff was there, so there wasn't any real prejudice, the case proceeded.
Well,
so if you'd won, you would have been happy, I assume.
Well, Mr. Richard Millard was for the ancillary defendant. He was not for the appellant. But the objections that I saw the appellant,
Counsel, that is a rather serious point against you. So if
I am aware of that. That's why I am.
It's Mr. Richards who is taking such objection or expressing misgivings about being inconvenienced as were expressed. Counsel for Gloria seem to have been entirely content for matters to proceed.
Yes, in fact, if you look at page 711, this is Ms. Vidal, who says well, she just had some objections in relation to the contents of some witness statements and wanted to object to one or 2 points in them, but the judge decided it was best not to do with them then, but when he heard the witnesses. So he's quite happy for the witnesses' statements to go in as evidence and there be no sanction.
Well, this is an issue I face with on the documents, and it is in fact correct that the objection was more by Mr. Richard than by Ms. Vidal. So
and it wasn't really an objection. Certainly, it wasn't an objection to the trial proceeding. There was no objection to the trial proceeding.
It was a moan rather than an objection.
Well, and the court said, okay, well, we will take them one at a time when the witnesses are sworn, and then Ms. Vidal says, very well. So I don't see an objection.
I think you would be better off allowing us to treat with this aspect of your appeal on the written submissions and go on to another point, Mr. Lawrence.
Yes, please, Ballard. Ballard, the other point I wish to present for your Lordship's consideration is that on the record that there were a number of non-compliant issues with respect to the witness statements, and we had argued we were given leave to argue that point in the court below. Let me indicate, my Lord, that was not canvassed at the trial, but with the leave of the court, we did address that issue at the appeal stage.
Can you be any better off in relation to those non-compliances than you are in relation to the trial bundle? Can you be any better off in relation to the witness statement point than you are in relation to the trial bundle point?
My Lord, our short answer, my Lord, would be yes, because in the face of the non-compliance on the witness statements, that there would have been sanctions that had already attached to that, and the only way that they could have been proceeded with is if either the sanctions were obtained or if permission was given on an application.
And
the rules
just a minute, Mr. Lawrence. Our technical officers have asked me to verify that Mr. Bruni is hearing all that is being said. Mr. Bruni, are you hearing me and hearing everything that's being said?
Yes, we are hearing everything clearly. Our mic is muted to avoid feedback.
Sorry, could you go that again?
I said, yeah, everything is clear. We are seeing everybody clearly. We are hearing everything clearly.
I see.
But we keep our mic muted to avoid feedback. That's why my mic is muted.
I see. Okay, right. Fine. Okay. Yes, proceed, Mr. Lawrence. You were asking a question.
Yeah. Sorry, I forgot what was the thread of it. The witness statement, that's the point you were making.
Yes, please, my Lord. Because, my Lord, we, for example, would have gone on to paragraph number 17, for example, of the submissions that refer to the late filing, the non-compliance in relation to witness statements. And what we propose to the my Lord is to look at the decided cases in the jurisdiction to confirm and to submit that there was a case management obligation on the linear trial judge not to have those evidence proceeded with on the basis of those statements. If sanctions, relief from sanctions had not been previously obtained, or if an application for permission had not been made before.
But surely the trial judge must be regarded as implicitly have given permission for the witness statements to be used, since they were used and they were cross-examined upon.
Well, in looking at the record, our submission, my Lord, would be that the rules do not refer to implicit relief. The rules require, Part 26 require an application for relief and relief to be granted.
Counsel?
There must be compliance with Part...
Counsel?
Yes, please, my Lord.
The essence of it is that parties are required to comply with the rules, and if parties do not comply with the rules, then there are certain sanctions, and the way that you get beyond the sanctions, the way you get around the sanction, is you apply before the trial for relief from sanctions, and you need to get an order for relief from sanction. So that is what takes place at the case management or the pre-trial review stage at the latest. However, what took place in this case is that at the trial, the point was taken that there had been non-compliance. This is, as my brother pointed out, at page 711 by Ms. Vidal. Page 711, line 8. My Lord, we have some objections in relation to the contents of some witness statements. I'm not sure if your Lordship will entertain them after the witnesses have been sworn or before. So the objection that was taken was in relation to content and not to late filing, not to late delivery. So the lateness was accepted by all parties. There was an acquiescence in it. If the objection was not taken before the trial, can it now be taken?
But my response, my Lord, would be, I have to concede it was not taken at the trial. But it was, we were given leave to argue.
No, hold on. You were given leave to argue it at the Court of Appeal, that's fine. That's not what I'm asking you. I'm asking, given...
Well, I have conceded.
No. You have conceded, therefore we have clear. Objection was not taken. Therefore, can you now rely upon the objection which was not taken? Can you make the objection no, in other words?
But no, it was not taken at the trial. But that notwithstanding, my Lord, my submission would be that there was a case management requirement that in the face of non-compliance, my Lord,
Counsel, we have gone through that. We have said where the objection could have been taken, case management conference, pre-trial review, and, in fact, at the outset of the trial. No objection was taken. Therefore, the question is, can you take the objection at this stage?
Well, my Lord,
Mr. Lawrence, I think like the previous point, it is better if you allow us to treat with this issue on your written submissions and you move ahead.
Very well, my Lord. Well, my Lord, maybe we should just go to ground number 2 then, my Lord. Because the remainder of ground number 1 has to do with the issue of the late filing and the non-compliance.
Yes, ground 2 is, remind me of ground 2?
The second ground would be ground number 1 as we argued ground number 2, ground number 4 first. So we would now go to ground number 1.
What paragraph is that on your speaking note?
On the speaking note, it is paragraph. On page 27, my Lord, that would be paragraph 57.
Sorry, what? 57? 27.
Yes, please, my Lord.
But 57.
Yeah, 57.
57.
Yes, please. On page
Yes,
27, paragraph 57.
Yes.
Counsel, before you get into that, I need your assistance. The question of delegatus non potest delegare is in relation to whether Gloria could have, by the exclusive agreement, delegated her power to Hillary. Is that correct?
That is correct, my lord.
But given that the trial judge found that Gloria did not, in fact, delegate her power to Hillary, that the exclusive agreement was a fiction, how can we consider the legality of the delegation when you are stuck with the finding that there was no delegation?
Well, I had a slightly different understanding. My understanding was that it was that the power had been, there was an attempt to delegate the power, but it could not be delegated.
Absolutely not, Counsel. Counsel, you will not succeed on that. Page 216 of the record. The judgment, paragraph 50. Are you there?
Yes, Mr. Malone, I'm reading it.
Okay. Could you read the last two sentences?
The exclusive, beginning the exclusive agreement, Malone?
Right.
Yeah. The exclusive agreement is no more than a fiction concocted by Hillary and Gloria in an effort to withhold from Angel a substantial part of the proceeds of his property. Hillary must repay the sum which have improperly come into his hands.
But finding that the exclusive agreement was a fiction which was concocted means that it did not exist, right?
That's correct. That's the finding of the trial judge.
Then, how do you move beyond that?
But, my lord, there seems to have been a different position taken by the Court of Appeal.
That's not true. That is not true.
My lord,
if you look at page 42 of the record, the Court of Appeal at paragraph 12 expressly states the exclusive agreement was no more than a fiction concocted by Hillary and Gloria in an effort to withhold from Angel a substantial part of the proceeds of his property. So it clearly wasn't intended to be a proper estate agency agreement. It was presumed intended to evidence a deal, presumably, a part of a plan to defraud Angel of part of the proceeds.
At page 42, my lord?
Page 42 of the record. Somewhere else later on.
And then you should continue to read on page 61.
Yeah, paragraph 56.
Yes. Where the court says Cottle J was scathing of the exclusive agreement and likewise scathing with respect to the credibility and honesty of Hillary. He gave cogent reasons for so finding. Cottle J described the exclusive agreement as a fiction concocted by Hillary and Gloria in an effort to withhold from Angel a substantial part of the proceeds of his property. In my judgment, it was entirely open to him on the evidence so to find. He found that the payments to Hillary were made without authority. He also found that there were no unpaid loans by Angel to Hillary. He found that the exclusive agreement was invalid. The judge's conclusions with respect to the central factual issues in this appeal present a formidable, if not complete, impediment to the success of the appeal on the factual issues. The findings made by the judge were clearly open to him on the evidence and could not be said to be against the weight of the evidence. Cottle J was correct in dismissing Hillary's counterclaim. And I think with all that you argued in your submissions there, I couldn't find any attack on that part. And if it is then unattacked, then I would say that is the fact that we have to accept. And if that is so, then there can be no discussion if the agreement was not an agreement at all. That would almost seem the end of the case.
Well, look, I'm guided by your Lordship's assistance with respect to the finding of Cottle J and of the court. But that notwithstanding, there seemed to have been, from my understanding of the judgment anyway, an acceptance that. But let me rephrase the submission. May I just have a very brief moment, please, Malone?
Yes.
Yes.
But with respect to this ground and the ground 2 and 3, I think I will rely on the submissions before your Lordship in the speaking notes.
Yes.
Is there anything remaining for you to argue?
My Lord, no, my Lord, I would, as I indicated, my Lord, I would rely on the submissions and the speaking notes, my Lord, as they are presented for your Lordship's consideration.
Is that the close of your submissions?
Yes, please, my Lord.
Yes. Mr. Bruni, do you have any response?
Please, my Lord and Lordship. Basically, I've followed your Lordship's questioning of counsel for the appellant, but I do not think I can assist very much, except to say that the witness statements were in fact filed in accordance with the case management order that was executed. Although the trial bundle may have been late, there was no need for the application that my learned friend was suggested of the court to actually have the witness suspended. Because in fact, it was the subject of a case management order. They were filed and served on time. The only deficiency was that there was an application for relief from sanctions that was not dealt with by the lead judge in dealing with the application for late starting of the witness statement.
Just a minute. You said there was an application that had been filed, or was it made orally?
There had been an application that was filed for an extension of time for filing the witness statements. In fact, it was exhibited to the submission of learned counsel for the appellant as Annex 1. It's on page 1665 of the trial bundle.
Page what?
What page of the record?
1665 of the record.
166?
5.
1665.
Yeah. So there's an application that was filed prior to the trial, that's in February. The court granted the application, extended the time to the 31st of March, which is the order is on page 1669 of the bundle. But the trial judge, or at least the judge in chambers, omitted to deal specifically with the application for relief from sanction. So that what the respondent is arguing is that the witness statements were filed on time, and the judge rightly allowed the witnesses to testify in the trial without the need for formal permission. As far as the arguments on the delegated power of Gloria is concerned, the appellant has the very same view. If you look at our submissions, which would be contained in page 1667, from page 1667 to 1712 of the record, we deal with the question of the new arguments introduced by the applicant before the courts and refer to an authority in this regard from the Privy Council. We also look at the overwhelming evidence of the fiction, the purported fiction, and the conclusion of the court. The other aspect that we would like to bring to the court's attention is quite apart from the arguments that my learned friend advanced about the agency. There's a question of the fiduciary obligations of the appellant. So even if one would accept all the appellant's argument that in fact there was a proper delegation, which of course we deny, then you would have to cross the bridge as to whether the delegation was not in breach of the fiduciary relationship. Well, Lords, we ask the court to consider our submissions and find in our favor with costs to the respondent.
What costs would you ask for if you were to succeed?
We, in the case management list, we indicated that we were asking for costs as provided for in the rules, so the prescribed costs in the rules.
Basic costs?
I think my learned, the basic costs as for two council as provided for in the CCJ rules.
Now, at the trial court and the Court of Appeal, costs were provided for?
In both cases, costs were awarded in our favor, so we're also asking for costs at first instance and in Court of Appeal.
Sorry, repeat? Could you repeat?
No, I said we're asking for costs at first instance in the Court of Appeal and at the CCJ according to the rules of the CCJ, the basic costs.
Yeah, costs were ordered in your favor at both lower courts. Right.
So that
if you succeed, those orders are upheld, and you need now only costs in the CCJ.
Yes, Lord.
Okay.
I'm not sure. We have to look at it. Yes. According to our table of basic costs, and in the case of an appellant, when two attorneys at law appeared, the costs that are payable normally from the notice of appeal up to and including the first day of hearing are in EC dollars $56,700. Now, those are the costs that you are claiming should you succeed, the cost of the appeal.
That's what we will be claiming from this court should we succeed. But we are also asking the court to confirm the orders of the two other courts as it was.
Yes. Of course, the court has not made up its mind on the result of the appeal just yet. But Mr. Lawrence, is there anything that you wanted to say on the question of costs?
Lord, on the question of cost, my Lord, we would have, as the Honourable Court, that if we are to succeed to make a cost order in our favour, as we have requested, my Lord, in our submissions, my Lord, if we're to succeed,
yes,
if we consideration fact has two orders against her.
Sorry, I didn't get that last part.
Also, we're saying, my Lord, that if we're not to succeed, we ask the court to take into consideration that there are two cost orders against the appellant. There's a cost order in the High Court and in the court below, my Lord. And we would ask that though the court has a discretion to award costs as indicated earlier, but in looking at the fact that there are two cost orders, that maybe a reduced cost order will be made against the appellant if we're not to succeed.
I understand. Okay, we take all of this into account.
Just one question. I noticed that before the Court of Appeal, there were Ms. Shillingford was, or Mr. Shillingford, Hilary Shillingford was an appellant, and also Gloria Shillingford and Rashida Pierre. But in this case before us, we only seem to have one appellant, which is Gloria Shillingford. Does it mean that the case is limited to her, and that the case could, with respect to the other two, are outside this appeal?
But there is an appeal by Hilary Shillingford. I do not think it has yet been heard. My understanding that there is, in fact.
When I read the first page of the Court of Appeal, there were two appeals, Hilary against Angel and Gloria, and then one between Gloria and Rashida against Angel. Both appeals were decided by the Court of Appeal, and both appeals were dismissed. Now here before us, we only have a notice of appeal from Gloria. So the question is, I have to assume that the appeal is limited to her, and that decisions taken with respect to the others are outside this appeal.
And similarly, in the event that she succeeds, that costs will be awarded in her favor, and in the event that she doesn't succeed, costs will be awarded against her.
Yes, my Lord, that would be a reasonable position, because the others are not involved in this matter.
Yes.
Sorry, but were you indicating that Hillary has a separate appeal?
Yes, my Lord, a separate appeal has been filed.
To the CCJ?
That is correct, my Lord.
Ah.
That is pending?
That's my understanding, it is pending.
Just by way of clarification, he did appeal for leave and was granted leave in the lower court, but as far as I'm aware, no notice of appeal has been filed.
Okay.
Okay, but Rashida is outside any of those appeals. So the decisions...
that is correct.
So the decisions which were taken with respect to her stand. Correct?
Yes, my Lord.
Yes, Mr. Lord.
Okay, well if and when that appeal by Hillary comes to us, then we'll deal with it accordingly, but it just boggles the mind that there can be an appeal in this matter that is still pending and that was not heard simultaneously with this one. But we will deal with that as and when it is necessary to deal with it. I think that's the end of our business today. We would reserve our judgment and endeavor to give it within the next few weeks.
We much obliged.